a production of the New Jersey Courts.
So you became a municipal judge in Washington Township in 1972, correct?
Well, I was probably nominated in 72, but I started January 1st of 1973. The New Year's, the annual reorganization normally is the first of the year. So in January of 1973, I became a municipal court judge in Washington Township.
Now, how often are you serving on the bench when you're a municipal court judge?
We started, it would be every Monday evening and Thursday afternoon. It developed that sometimes we would have to have a few more sessions. There would be, because of where Washington Township is located, at some point the police had special DWI patrols, and so our motor vehicle tickets increased for that activity, and those trials can be longer. The activity during the course of a trial for drunk driving charges can take some time. That time was a time also where the statute was difference between an A and a B violation, A being more serious, B being less serious. So there were different mechanism where you could maybe downgrade an offense. The attorneys would discuss it, and while it might be close to an A, it might be downgraded to a B. So that would take up more time. Every type of lower crime that was in the town, whether it was shoplifting, whether it was a neighbor dispute, all these came before the municipal court. And so I was exposed to a lot of different activities that were going on in the town.
Now, when you take a position like that, do you get any kind of training, or are you required to go for continuing education? Or?
Well, you're required to go for continuing education. I really didn't get any training. I was sort of on-the-job training. I think I may have gone in and said it on a prior session. You may have known from your own experience, if you were had municipal court, you knew how some judges acted, and you pick and chose as to who you wanted to emulate and how you compose yourself on the bench.
Well, for you, what was your solution to that? Who'd you want to emulate, or?
I don't think there was any one person going into municipal court to emulate, but I was pretty much myself. I was always a very calm and considerate of others, never rude, try to give the person the benefit of the doubt. I would ask you to do something rather than tell you to do something in the courtroom. And when you wear a robe, people generally listen. They generally listen. I never had a problem with someone not doing something that I asked them to do. So my courtroom was run very fairly and without any rancor of any kind.
Was it difficult to juggle this responsibility with your law firm?
I did not find it. I found decision-making very easy. There were some tough cases, but I found that to make the decision was easy, and I was one that I made the decision and moved on to the next case. I realized I wasn't going to rewrite 100% of the cases, and that's why they have appeals. You learn this more as you go through and become more experienced. You get a little defensive when you're maybe your first or second appeal, but then you realize that someone just feels that you didn't treat them fairly, and there are legal issues that someone else needs to look at, and that I learned more as a Superior Court judge later on than as a municipal court, because I rarely knew that if there was an appeal, and most times there is not an appeal, because there are motor vehicle offenses, and the cost to appeal is more than maybe the fine was at that time. Fines were in the $25, $30 range, more for drunk driving, but generally, if you didn't have your license with you, it was maybe $10, $20. Now it's the fines are much more significant. But there were different offenses, and most people did not appeal.
What's interesting, this was, at least from my own sense of it, 10 years before there were a lot of public information campaigns about drunk driving and that sort of thing. So
Yes.
was that, were they handled differently, or was this part of the effort to curb this problem?
Well, it was part of the effort to curb the problem, but the breathalyzer machines were in existence then. While they're relatively new, you still had the process of certifying the machine and making sure that it was operating properly. And so that was the process, and that evidence coming in was important, and you need it for a conviction. But it was the defense and first of all, the apprehension, trying to prohibit drunk driving was becoming more and more of a responsibility of the police force at that time. So once they made the stop and they found someone reasonably looked like they were under the influence, and they had the breathalyzer test, the breathalyzer would confirm that or not, then it would be issued a summons.
Now, aside from the criminal work, was there any other aspect to presiding over the court then?
There were neighborhood disputes. They weren't really criminal, but you know, when you have your dog is always barking, there's a fence issue, the tree has fallen on someone's yard and there's an argument, there may be some limited assault type issues. There were the minor. If it was serious and physical assault that was with injury, that would probably come to me, then go to the county for look at for indictment and process through the county facility or state at that time. But there are a lot of interesting cases, and some of the neighborhood people just can't get along. You found out in life, and I was always very happy that the neighbors I had. They were good throughout my life.
Well, on that level, again, I'm speaking as an amateur regarding the law, but you know, how much discretion do you have in terms of saying, you know, well, there's these mitigating factors that
I had a lot. I had a lot of discretion. In most cases, with the neighbor dispute, I would try to resolve it in a fair way that did not really mean fines, but trying to get the people to learn how to get along with one another. Occasionally, you couldn't do that. You had to find someone guilty of whatever the offense might be. But I had a lot of flexibility in those cases. I think in this day and age, they may have settlement committees that try to resolve that type of case. Unfortunately, I did not have that when I was sitting and heard them from the bench.
And in the criminal cases, were you able to look at things like, say somebody was shoplifting, like, well, they come from a home where maybe this is part of acting out. Would you consider those kinds of things, or was it more?
I would consider those kinds of things in the sentence aspect of it, but not insofar as if the proofs were such, I'd find them guilty. If there was some reasonable doubt, I'd find them not guilty. But most of the time, there was a guilty plea. When you had to try it, as I said, if there was reasonable doubt, I would enter a finding of not guilty. If not, if it's beyond a reasonable doubt, then I would enter a guilty finding and then listen to any mitigating factors when I impose sentence.
So you said you served three-year terms.
Yes.
And then in 1984, I believe you were.
Yes, in 1984, I was appointed to the Superior Court in New Jersey. I was practicing law with my law firm at the time, and I got a telephone call from Marty Herman, who was an assemblyman at the time, and he asked me if I wanted to be considered as a Superior Court judge. And I said, gee, Marty, I'm thrilled, but I'm not sure it's the right time for me. I have 5 children, all of them. My oldest was near college starting age, so college tuition is a factor, and I knew that money would be a factor. So I said, I'm not sure it's the right time for me. So Marty said, I think you're the right person, but you can't always pick and choose when you want to do things. He said, when you're ready, maybe the system won't be ready for you. So I said, well, give me a couple of days to think about it. So I went home, I talked about it with my wife, and we decided to go ahead and consider it. And I called Marty back and told him, yes, I'd be happy to be considered. And so I then went through the process of being considered for a Superior Court judge, and as it turned out, it worked out.
Now, was that just after the reorganization?
That nothing to do with municipal court.
Yeah.
When you say reorganization,
where
the county courts.
Yeah, the county courts.
Yes,
and,
it was. The family part judges were just coming into being, and there was a reorganization where all the judges were now going to be Superior Court judges. So yes, it was right around that time. So when I was nominated, you were nominated for a Superior Court judgeship, not for a county or state judge. They were all state judges at that time. Oh. The only distinction was whether or not you started in family court. They added more judges in the system because of the family court system, the family court law that had been imposed that established the family courts.
So tell me about getting sworn in, finishing the process of becoming a Superior Court judge.
Well, it just so happened that Elliot Hurd, an African-American attorney in Woodbury, also was being considered for a Superior Court judgeship. And it turned out that they added sufficient judgeships for this area that both Elliot Hurd and myself could be appointed, and we became the first African-American judges in this county. We were sworn in the same day, May 31st of 1984, and operated thereafter. I was assigned to the family part. Let me back up. Judge DeSimone was the assignment judge. He assigned me to family, and I sat here in Woodbury for about 3 months. And then because we being Gloucester County had a couple extra judge positions, Camden was short of judges for some reason. And Atlantic County was short. So it turned out that Judge DeSimone asked me if I would sit in Camden for a period of time to help them out. So I said I would. I don't know whether I had a choice or not, but in September I went to serve in family part in Camden, New Jersey. At that time, Judge Page was the presiding judge and one of the well-known, outstanding family part judges. So I was able to work with him. I learned a lot about family law, and it was a good experience, and I got to know all the judges there in Camden County, as well as the attorneys, and exposed me to a lot of different people that I had not interacted with before. And the commute was not bad. I lived right off of 42 in Washington Township, so I drove right into Camden. So the commute was just a little bit longer than Woodbury, so it wasn't bad from that standpoint, and it got me exposed to a lot of different things. One of the nice things was the assignment judge in Camden said that if I came to Camden, I would be able to attend the general course for judges in Reno, Nevada. And that was a period of time when the local counties were, in their budget, they provided for sums for judges for educational purposes. So part of it was I was able to get my own law clerk, as well as to that following spring to attend the the general course for judges in Reno, Nevada at the Judicial College out there. So I was exposed and learned a lot of things that got me back near the West Coast, and I would deviate and go visit my friends in California, then come back. So I was very fortunate in that respect.
How do you think that affected your, presiding over your court afterwards, what you learned in Reno?
Well, I think it all helps. It teaches you, as well as other things that you're experiencing, that you want to have a level head when you're making decisions. If things get a little hot and heavy, you learn to take a recess. If most people listen to the person in charge, being the judge. I had a gavel. I don't think I ever used it. The court attendant would announce you're coming in. You come in, you sit down, you go through your procedure, make your decisions. You hear the litigants and the attorneys before you. I like the interchange with the hearing the attorneys, their arguments, the jury trials that subsequently developed when I moved to civil and then to criminal divisions. It was just a good experience. It made me learn the law more in depth in the areas that I was assigned to, and just gave me an opportunity to do things that kept you fresh and vibrant and anxious to get into court.
Well, tell me about, again, without revealing names or anything, but a typical experience on a case in family court.
Well, one of the drawbacks of family court is that you get to learn that all people are not good. I always approach people, giving the benefit of the doubt, thinking they're doing the same things that I'm doing, and are basically honest. But when you hear some of the abuse issues in family court, that people do not treat their children the way you may have been treated yourself. They abuse children. Some of the really abusive things you would hear would be shocking. And yet you had to keep your composure and listen to all the evidence and then make your ruling. And I mean, there were difficult decisions you had to make. I recall one case where I had terminated the defendant's rights to a child because of his abuse of the child. Actually, children. One of the children subsequently died. So 2 years later, he petitioned if he could go to the funeral. I heard his argument. Initially, thought that he should be able to see the child in a isolated location. Went back in, thought about it, and then said, well, he has no rights. I couldn't do that in opposition to the new custodial parents that were opposing it. So I rendered my decision and made a tough one call to say that he couldn't attend. But these are the sort of gut-wrenching some of the gut-wrenching decisions you had to make because of the conduct of individuals throughout the county.
I was in reading through some of the opinions you authored on the Supreme Court. There were a number of DYFS-related cases.
Yes.
And it seemed like you dissented in some of them and always arguing for maybe a higher standard for terminating the parental rights. Was that something that you...
Well, I don't know. I don't recall things in that mode as far as that being the issue. Depending upon the case, I may have said that they did not meet the standard. I don't know whether I asked for a higher standard at times, but some cases I may have felt that the evidence did not satisfy that standard based upon how I read the record and the arguments. But there were some difficult cases that throughout, and I do recall a number of not the actual issues, but having decided a number of division of DIFAS cases at that time. That time being when I was on the Supreme Court. And part of it may have been from my experiences. You know, I saw a lot of things that went on, interacted with many DIFAS workers, a lot of probation workers, a lot of people in the system. So I knew a lot of the players. Most of the cases that I heard in the Supreme Court, I may not have known those players because they're throughout the state at the Supreme Court level. When I was in the counties, of course, you knew the players more, so to speak, about the workers, but not at the state level.
So you said after the family court experience, you went to
yes,
the criminal?
I was in family for 2 years.
Yes.
Then I came back to Gloucester County and was assigned to the civil division. And I worked in civil for several years. That's where I started having jury trials, and I really liked that aspect of it. The motion practice was you delved into the various legal issues and a short opinion on different issues, which was interesting to me. One of the cases that I had that wasn't as interesting as I would have liked was what I call the dirt case in New Jersey, and it dealt with the building of Route 55, where they had to level out the ground, so they had various cuts and fills, and there was a lawsuit that was brought against the state alleging that the company was not properly compensated for all the work that they had done. And I called this the dirt trial because it not only was it about dirt, but it also lasted 4 or 5 months of a bench trial. And we didn't try every day, but it was over a 6-month period that the case was tried. So that was one of the not so great memories, because it got to be a little dull after a while with the various evidence. But of course, plaintiff had to prove his case, so there was a lot of evidence that was brought in, a lot of paperwork, and then a request for findings of fact and conclusions of law, and then I had to write an opinion from that case. But yeah, there were a lot of more interesting cases throughout that I really liked. And then after the 2-year period in civil, Judge D. Simone assigned me to the criminal division. And I sat in criminal for, I think, 2.5 years. And he was getting ready to assign me back to civil. And that's the time that I was asked to sit in the appellate division. And at that time, while on the criminal division, I sat and heard a session of criminal and civil cases on the appellate division. Judge Michaels was the presiding judge for the panel I sat on. And I was assigned 4 opinions to write. So I come back and I write my 4 opinions while I'm on the trial bench here. And apparently I passed, so that following September, I started on the appellate division full-time, and I was there for 11 years, I think.
Well, before we leave the
trial,
yeah. Tell me about maybe 1 or 2 criminal cases that you recall, because you had dealt with obviously the smaller crimes in municipal court, but now
yes.
You're dealing with more serious crimes.
Yes. Well, I had a number of murder trials, of course, and one of them in particular was a case that was out of Franklin Township, where it was like they found a body on a disposal area, a landfill disposal type area, and the lady was from Maryland. So there were issues about jurisdiction, whether or not the death had occurred in New Jersey. Ultimately, the boyfriend of the woman was indicted and brought to New Jersey for trial. And after we found there was jurisdiction from the evidence that was presented, to show that the body had part of the incident had happened in New Jersey. So the trial occurred here. It was a very interesting trial. A lot of it was inferential evidence. There was no direct evidence that really showed that he had, I think, bludgeoned her to death. But the compilation of everything, the evidence showed, and the jury found that the defendant was guilty. And that was the factual aspect was interesting to hear. Of course, you limited the charge in the jury. The jury's making the decision, so the case is really easy for the judge, other than some legal issues that come up during the course of the case that you have to decide. But it's interesting. You take your notes, you know about the case, and then you charge the jury, and the jury has to do their function.
Now, I'm curious, this would have been just before DNA evidence became widely used?
Yeah, it was before. I don't know about just before, but it certainly was before, because DNA evidence was not part of the issues. None of the evidence developed. But later on, DNA became very important and freed a lot of persons that were not guilty.
Well, tell me about the transition to the Appellate division. I've been told that's a very different animal.
Oh, it is. Yeah. It is, and it was. I was apprehensive going to the Appellate division because now I'm going from a more of a listening, decision-making, orally, promptly move on to the next case, interaction with attorneys and juries, situation to getting a lot of paperwork from briefs. Consulting with side judges, and then hearing oral argument of limited persons, and then making a written decision. So it was really a different type of judging. And I had really liked the interaction in the trial court level. I'm more of a people person, so I was able to do that on the trial court. And the Appellate division is a lot different, a lot more work. At the trial level, it was basically a 9 to 5, a little bit of work in the evenings, but Appellate division the hours are unending. You work all evenings, early morning, but you have flexibility. You can do a lot of it at home, a lot of it outside of the office, and your office may be in a office building as opposed to a courthouse. So you dress differently. You're not coming in, you're not wearing a robe, except when you have oral arguments. And I got to like the issue finding, the issue developing, the opinion writing, the sort of tracking and putting the pieces together of the puzzle to render an appropriate decision. I was very fortunate that every presiding judge that I sat with, they were wonderful to work with. They worked as hard as anybody on the panel. In the Appellate division, the panels are either 4 or 5 judge panels, and there were tough cases and easy cases. You may have had 12 cases on an argument week, and of the 3 judges, each would get 4, so you have 4 opinions to write. A couple might be easy, one may be okay, and the other was very difficult. So it ran the gamut. The administrative people would give you a projection of the degree of difficulty of the case. If it was an extremely long case, there was also a central research department that did research on those cases and came up with a central research memo as a recommendation of how to handle the case. You had your own law clerk. On the Appellate division, every judge has a law clerk. The presiding judge had 2 law clerks, and after a while, the second senior judge also had 2 law clerks. The presiding judge would assign each law clerk to a memo for various cases. So if you had 12 cases on the list, you normally had at least four memos by a law clerk. The other 8 or so would not have a memo on it, unless maybe there was a central research memo on it. So some cases you had guidance from, or at least a recommendation from someone who had delved into the case. Other than that, you delved in the case and you were the law clerk as well as the opinion writer. You're always the opinion writer. The law clerk never wrote the opinion for you. You may have used some of the substance that was developed for you when you rendered your opinion, but you wrote your own opinion as a judge. So there's a lot of work. Just briefly, the procedure you probably know, but in the appellate division, you get some boxes of cases. Let's say there are 12 that are going to be heard 2 weeks. So you review all those cases and get prepared for the oral argument. Not all of them are argued orally. Some are waivered case, so you just decide the cases on the papers. But what each judge does that's assigned to the case would write a brief summary of how he or she recommends deciding that case. And you send it to the other judges on the case. You then may have an oral discussion about the issues, if you agree or disagree. If it's an oral argument case, you hear oral argument and you discuss how you want to decide the case, both before and after argument. And then the presiding judge would assign who's going to write the opinion. And this, every week, for at least 5 weeks straight, you have these 12 cases that you hear and decide. So there's a lot of work and a lot of time that you don't have, but you have to write the opinion as well as prepare for the next batch of cases. And our appellate division is a very hard-working group of individuals. And it was different aspect, different type of work. My son was in playing high school baseball or sports, and excuse me, I'd be off in the corner with my briefs, reading them and watching the activity. When there's a lull and then what was going on in front of me, I'd have the brief in front of me. I used pretty much every opportunity I could to stay abreast of what I had to work on. If I went somewhere, I took cases with me. I can remember taking a trip to the islands, some location, and had a box of cases. I drafted an opinion. You did what you had to do to get the work done, keep it flowing, as well as being attentive to what you were doing at that location.
Now you had some cases that I guess reading now seemed a little controversial at the time, but like there was a police officer killed and his person was denied, his killer was denied parole for a while. I think it was Tarantino,
I think.
Tarantino.
Or something
Okay.
like that.
Yeah.
Yes, I was on the appellate division.
Yes.
I was, and in fact, I was sitting with Judge King when we heard that case, and he was up for parole, as I recall, and my fact could be off, but the issue is, as I recall, was he was up for parole, and using the criteria that were set for parolees, his record was such that he should have been granted parole, but he was denied parole. It was a sensational trial. He had killed a police officer. Nobody liked what had occurred, but from a legal standpoint, we determined that he should have been given the right to have parole. I think he had been on some sort of release program that he had done well on, and everything was progressing well. And we ended up, I think, reversing what had been done, granting the parole. It turned out, fortunately for us, that he went to a halfway house or whatever they called it, and everything turned out well eventually. We were heaped on with criticism. It was very controversial. And every time I came up for some appointment, that would always be raised.
I'm curious, like at the time when you're trying this, do you have to deal with press at all, or
No.
mail or anything?
No. I very rarely was there a press issue that I dealt with. The assignment judge may well have, but I did not. There would be maybe press in the audience. They hear the case, they go back and write the report, but I never spoke to them about the issues in the case. It's not like what you may see on television about judges and reporters.
So there's really no outside pressure. It's more just examining the law.
No, it were really impressions that you impose on yourself, pressures that you impose on yourself, trying to do the right thing, recognizing that everybody's not going to be happy no matter what you do, making decisions based upon what's right for that case, not what's right for something down the line for your future. But yes, that was a case that I'm sure did not help me for future advancement, but things turned out well, and it didn't hurt me either, apparently.
Any other cases spring to mind?
One case that I dissented in the Appellate Division, and I'm not sure whether this pronunciation is right, it may have been State versus Gookins. It happened to be a municipal court matter, drunk driving, that had come up, and I'm now in the Appellate Division. And I think the issue was this police officer, there had been evidence that he had falsified the readings for blood alcohol test. And in this particular case, I think the defendant motorist, who had been charged with drunk driving, wanted to bring in other evidence of the wrongdoing of the police officer. And that had been denied at the trial level. The Appellate Division approved what had been done at the trial level. I wrote a dissent. Fortunately, the Supreme Court, they have to grant it when there's a dissent, and they reversed, so the evidence only was able to come in. But I had an internal clock that went off, because having sat in the municipal court, I know the evidence that's presented, you give a lot of credibility to police officers with regard to the reading of the breathalyzer. And if there's evidence that the police officer has falsified that reading, I think it's evidence that should be considered by the fact finder. And for some reason it was denied and ultimately allowed to come in. So that was one of the more interesting cases that I had, probably the only dissent that I can recall in the Appellate Division. Because in the Appellate Division, you try to meld your view and to come out with a unanimous result if you can. Some cases you can't.
Now I'm curious, you described how hectic the work schedule is, but you still continue to be quite active in coaching and that sort of thing?
Yes. As I said, it gave you flexibility, because you didn't have to do it between 9 to 5. I could leave the office at 3 o'clock, go to a football practice or whatever it was, and finish up at practice at 5:30, 6 o'clock, have dinner, and then work till 9 o'clock, whatever it took to get the work done for the Appellate Division. I'm an early riser. I'd get up in the morning, work in the morning for a couple of hours before I would leave my house to go into the Appellate Division office. So yeah, the flexibility was sufficient to overcome the time constraints and the magnitude of the workload. It was very life-fulfilling, and work that gave you an opportunity to do something good, as well as to enjoy your life outside of the law.
Now you were also very active. You want to take a break now?
I'm good. It's only quarter. We can go a couple more minutes.
Yeah, I just wanted to ask about some of your committee work, and I'm going to pull out the list because I don't have it memorized. Like, for example, the Task Force for Minority Concerns.
Yes.
That was during your time on the Appellate?
No, I was on the trial bench.
Oh, okay.
That started in 1986, I believe. In fact, I may have been at the Judicial College in Reno when I got a call from Judge Davis about sitting on this committee. And he said it's going to be a lot of work, involvement, that he was asked to chair the committee. So I said to Judge Davis, I said, well, if you're going to be involved, I'll be involved too. And it was a great experience because I got to meet individuals of all walks of life in the state of New Jersey. The commission was, I think, a 52-member commission to start with. So there were a lot of people involved, a lot of important people. I got to know a lot of the players and shakers historically in the state, a lot of activist people, a lot of I think I first met Attorney General, former Attorney General at that time, James Zali, who we later on became members of the same court. So it was well put together commission, and did a lot of long, good work. Took a period of time, made some tremendous amount of recommendations, and many of them were accepted. That was the first one, and then on the trial bench, and that was, as I said, it took several years. I may have been on the Appellate Division when we gave our final report. Sorry about that. I thought I turned it off. I just turned the, for turning the volume down, it was pretty loud. Yeah, I turned it off. Okay. Sorry about that. Where was I?
You were talking about the Task Force for Minority Concerns.
Yes. All right. The Task Force for Minority Concerns. I think our final report came out. By that time, I may have been on the Appellate Division. But there was an interim report after a couple of years, and the court adopted many of the recommendations, one of which was to maintain a committee on minority concerns to continue and address issues that will be brought out during the course of the years ahead.
Mm-hmm. Do you remember if there was a specific aspect that you were working on, or?
I chaired a subcommittee on access of minorities to justice in the courts. I think there were four chairs. Attorney General Zali was one chair. I don't recall the criminal chair, and there was one other, but we were sort of like the executive committee, and we ended up writing, of course, our portion of the report for the recommendations and dealing with the various committees and the meetings that you had. So it was a busy time when you had your meetings, and some were controversial because not everybody agreed with every issue that was presented and the way it was presented. So it was challenging in that respect, but it gave you a chance to interact with, as I said, people throughout the state and hear arguments of various issues.
Did you incorporate a lot of social science evidence as part of
that?
We
did.
Yeah.
We did. We had experts that came in, gave reports to the court. We did surveys, and the experts analyzed the surveys. Yes, we did that too.
Do you remember any portions that were controversial?
Well, I guess a lot of the recommendations were controversial, but I don't remember per se all the recommendations, but the general recommendations was we wanted the court system to reflect what the minority population was in New Jersey along those lines, and any number of issues that were related to that. Treating people fairly, having an ombudsman in the court system for each county so that people had a place to complain if they were not treated fairly, and that things would change. And the atmosphere was that we wanted to welcome all people into the court and have them treated fairly.
And just quickly to follow up on these, you were on other special committees or task forces related to the Americans with Disabilities Act and matrimonial litigation. Well, maybe not matrimonial litigation, but I'm thinking of you were, but I'm tying issues together. Was that kind of a similar approach to make
yes, it was
the justice system more accessible?
Make the more accessible to persons with various disabilities. Okay. Yes, and then eventually, when I was on the Appellate division, I guess after being there for a while, I was asked to chair one of the committees and dealing with admissions to the bar, that was an interesting experience because now I'm chairing a committee and again, a lot of interesting people. And a couple of things that came out from that, we made a recommendation that persons that were members of the bar in outside jurisdiction be able to be admitted on motion. That was not approved by the court until recently. Now the court changed that about a year and a half ago or so. We also recommended that I think at that time there was a bona fide office rule in existence, which meant that every attorney had to have a New Jersey office, bona fide New Jersey office. We recommended, and the court accepted, that the bona fide office didn't have to be in New Jersey. So that rule changed, which we thought more emblematic of what some people were doing, and so people didn't have to go around the rule to try to meet the rule, so to speak. And it was just a nice experience. Most recently, maybe within the last 2 or 3 years, I I was co-chair. Second, the chair was Justice Lavecchia of a committee dealing with the National Bar Exam and whether or not New Jersey should adopt it. We recommended that it should. We also recommended the motion rule be established, and the court approved both.